What happens when a teenager is stopped by federal immigration agents in the United States? Two separate legal systems can become involved simultaneously: the immigration court system and the juvenile justice system. The process that follows is not simple, and the outcome is not predetermined. Whether that youth is deported or placed into the juvenile system depends on a specific set of legal classifications, federal laws, and court decisions. This is the real process, step by step, and every fact in this video comes directly from federal law and binding legal agreements. Let's get into it. A teenager can be detained by two federal agencies: Customs and Border Protection, known as CBP, or Immigration and Customs Enforcement, known as ICE. CBP handles apprehensions at the border and ports of entry. ICE handles apprehensions in the interior of the United States, in homes, schools, workplaces, and on the street. The moment a youth is taken into custody by either agency, federal law begins to apply. This is not a local matter. It is not a state matter. Immigration enforcement falls exclusively under federal jurisdiction. The first and most important question federal agents must answer is this: is this youth accompanied or unaccompanied? An accompanied minor is a youth apprehended with a parent or legal guardian. An unaccompanied minor, legally defined as an unaccompanied alien child, or UAC, is a youth who has no parent or legal guardian present in the United States, or whose parent or guardian is unable to provide care and physical custody. This classification determines everything that happens next. Under the Trafficking Victims Protection Reauthorization Act of 2008, known as the TVPRA, unaccompanied minors receive significantly stronger legal protections than accompanied minors. They must be transferred out of CBP or ICE custody and into the care of the Office of Refugee Resettlement within 72 hours of being identified as unaccompanied. Regardless of accompanied or unaccompanied status, all immigrant children in federal custody are protected by the Flores Settlement Agreement, a binding legal agreement established in 1997 that set the minimum standards for how the federal government must treat detained immigrant children. Under the Flores settlement, the government must release children from detention without unnecessary delay to a parent, a relative, or a licensed program. If a child must be detained, they must be held in the least restrictive setting appropriate to their age and needs, and in most circumstances, children cannot be held in immigration detention for more than 20 days. The Flores settlement is not a suggestion. It is enforceable in federal court. For unaccompanied minors, once transferred out of CBP or ICE custody, the Office of Refugee Resettlement, a division of the Department of Health and Human Services, takes legal custody of the youth,
or places the youth in a licensed shelter, group home, or foster care setting while the immigration case moves forward. OR's primary goal is to find a suitable sponsor inside the United States, typically a parent, relative, or close family friend. A home study is conducted on the potential sponsor. Background checks are run. If the placement is approved, the youth is released to the sponsor while the immigration court case continues. The youth does not disappear from the legal system. They remain in removal proceedings even after release. Every youth detained by ICE or CBP is placed in removal proceedings, the formal immigration court process that determines whether they will be allowed to remain in the United States or be ordered deported. A notice to appear is issued. This is the immigration equivalent of a charge. It specifies the grounds for removal and triggers the court process. Unlike the juvenile justice system, where the Supreme Court ruled in re Galt that youth have the right to appointed counsel, immigration court does not guarantee a lawyer at government expense. A youth can appear before an immigration judge without any legal representation. Organizations and nonprofits work to fill this gap, but legal representation is not a guaranteed right in immigration proceedings. Hold on, before we go any further. If you didn't know that a teenager can stand alone in front of an immigration judge with no lawyer, hit that like button right now. This is the information families need before they ever walk into that courtroom. Subscribe to Juvenile Justice Decoded, hit the bell, and drop a comment. Tell me what surprised you most so far. Now let's finish this. In immigration court, the youth or their attorney can apply for legal relief, forms of protection that would allow them to remain in the United States legally. The most common forms of relief for detained youth include asylum, available to youth who can demonstrate a credible fear of persecution in their home country based on race, religion, nationality, political opinion, or membership in a particular social group. Special Immigrant Juvenile Status, known as SIJS, is available to youth who have been abused, neglected, or abandoned by one or both parents. SIJS requires a juvenile court or state court to make specific findings about the youth's situation. This is one of the most direct intersections between the immigration system and the juvenile justice system. T and U visas are available to victims of human trafficking or certain crimes who cooperate with law enforcement. If a youth detained by ICE also faces criminal charges in the United States, whether from a prior incident or from conduct at the time of apprehension, two separate legal proceedings run simultaneously. The State Juvenile Justice Court handles the delinquency case. The Federal Immigration Court handles the removal proceedings.
These courts do not wait for each other. ICE can place an immigration detainer on a youth who is in juvenile detention, meaning that when the juvenile case concludes, ICE takes custody and immigration proceedings continue. A delinquency adjudication, even though it is not a criminal conviction, can still be used as evidence in immigration proceedings and can affect the youth's eligibility for certain forms of relief. The two systems feed into each other in ways most families never see coming. At the conclusion of immigration court proceedings, the judge issues one of two outcomes. The first is relief granted. The youth's application for asylum, SIJS, or another form of protection is approved and they are allowed to remain in the United States legally. The second is a removal order. The judge finds no legal basis for the youth to remain and orders them deported to their country of origin. A removal order can be appealed to the Board of Immigration Appeals and, if necessary, to federal circuit courts. The appeals process can extend proceedings for months or years. During that time, the youth may remain in the United States under supervision. If all appeals are exhausted and a final removal order stands, the youth is deported, returned to their country of origin by federal agents. Youth cannot be deported to a country where they would face torture or persecution without due process protections under the Convention Against Torture and the Refugee Act of 1980. But if no protection applies and no relief is granted, the removal order is executed. Two systems, two courts, two completely different sets of rules. A teenager can move through both simultaneously, with a delinquency case in juvenile court and a removal case in federal immigration court, and the outcome of one directly affects the other. The immigration system and the juvenile justice system were not designed to work together, but for thousands of youth across the United States every year, that is exactly what happens. If this video gave you information you needed, share it. Subscribe to Juvenile Justice Decoded for weekly breakdowns of the systems that affect youth across the United States. Drop your questions in the comments. Every question becomes the next breakdown. We'll see you in the next one.